Good evening. It is 9:09 p.m. on August 19, 2021. I just reviewed what is a 160-page opinion by a judge from the Southern District of Texas, U.S. District Court here in Texas, regarding the memoranda that was issued by issued in regards to immigration. And after reviewing the first 24 pages and making my comments and contextualizing it with an understanding that unfortunately I believe that not only was it issued in bad faith, but that it is not, and that it is demonstrative of the specific pattern of racketeering activity I've been trying to have prosecuted, but also believe that it plagiarizes my efforts both before the state of Texas and also on the federal level. That whoever was involved with creating whatever is supposed to be the state's claim from the state of Texas specifically actually literally used my efforts at due process within the state of Texas in order to file the claims that were adjudged today. I'm concerned because if I am not mistaken, in 5 days, it's going to be the anniversary of major benchmarks associated with the original passage of the Anti-Terrorist and Effective Death Penalty Act of 1996. And as I have been remarking and attempting to have redressed for several years now, that my former work as a journalist and editor at a newspaper in Chicago, where I covered a trial, which was one of the first major trials under the Anti-Terrorist and Effective Death Penalty Act, has been disappeared. And I am concerned that the reason it has been disappeared is because something happened with that very akin to what I just saw. I have done what I can to provide a response. I've reviewed only the first 24 pages. I stopped before the section regarding specific allegations of financial injury because I contend that the appropriate context for consideration of financial injury in this matter is not regarding third parties, but rather the state itself and its refusal to address its own malfeasance and other unconstitutional activities that I have been attempting actively to report in the state of Texas since at least February, actually December of 2016. So I will be reviewing that and doing what I can in that regard. I understand that there was a decision made regarding a request for, or demand actually, order for specific processes in how to implement elements of what has been discussed. However, it is also important to understand that whatever the impetus was and whatever the cognizability of the specific judicial actors or others that were involved in that case are, that I contend that it is very significantly more concerning, including the fact that it involves allegations that were originally presented under the former administration of Donald Trump than under the ones regarding the current administration of Joseph Biden, and yet reveal a very, very alarming activity up to and including the level of the President of the United States, and may actually right now be correlating with alteration of the official record of the country specific to this announcement and other matters ongoing concurrent to this announcement, including but especially related to the alleged transportation or the infrastructure package that is being considered before Congress. I would request, if possible, in consideration of what has been made aware through this particular opinion, that there be a injunction placed upon any further consideration or effort to vote on that infrastructure bill until such time as these matters are rectified.